everybody, and welcome to the National Constitution Center's online classes. I'm so happy to have you here today. My name is Jenna Karras. I am the Director of Learning and Engagement, and today's topic, we are exploring the 15 cases. They are right here on the screen that are included on a AP government and politics exam. So this is our introductory session. So this is a good session if you're thinking about taking an AP course in the future and you kind of want to get a taste of what you're going to learn about and discuss. This will be a great class to take. At 2 o'clock at our advanced session, we'll really dive in. We'll be answering your questions the whole time. And I could not do this without our top scholar, Tom Donnelly, who is going to walk us through all of these cases. Hi, Tom.
Hey, Jenna, great to see you.
Yeah. Like I said, students, I have on the screen here the list of the 15 cases. They are listed in chronological order, but we're not going to actually go in chronological order because the College Board and the AP people have kind of looped these cases together by theme. So we're going to go through the themes, but we are going to start at the very beginning because I think that first case, Marbury versus Madison, is really important for understanding what we're talking about today, which is the Supreme Court cases and Supreme Court decisions. So Tom, do you want to tell us about Marbury versus Madison and why it's such an important case to learn about?
Absolutely. So, I mean, Marbury versus Madison, it's one of the classic cases, one of the first ones you'll probably study if you go to law school. It's in 1803. It's a key case from Chief Justice Marshall's time as Chief Justice of the United States. And, you know, it's a case, as you can see from that first graphic there, that involves some really illustrious a cast of characters here from the founding. It involves John Adams, Thomas Jefferson, James Madison. Now, you probably don't know who Marbury is. Marbury was just a well-connected Federalist at the time. But this is a dispute that arises over Marbury wanting his commission to become a justice of the peace in Washington, D.C. This arose out of the famous midnight appointments at the end of the Adams administration. John Adams was defeated by Thomas Jefferson in the election of 1800. Adams is trying to put as many Federalists as possible on the federal bench before then. So he signs Marbury's commission, but he doesn't deliver it. And so this is Marbury's attempt to get the new administration of Thomas Jefferson and James Madison to deliver his commission. For the purposes of today, why is this case so important? Well, Chief Justice Marshall ends up using this case to establish the power of judicial review. And so this is that important power that courts have to declare certain laws or actions or practices of the government constitutional or unconstitutional. And so what Marshall says in this case is, Marbury, you're right. You actually do have a right to this commission, but we, the Supreme Court, do not have the power to grant it to you. And in doing this, what Marshall does is he actually strikes down a law passed by Congress, giving the Supreme Court the power, saying that when Congress passed that law, it exceeded its power in that circumstance. So here, the Supreme Court does not have the power to give Marbury's commission. But in the end, the key point here is that John Marshall is using Marbury versus Madison to establish his power of judicial review, which would be so important for the rest of the Supreme Court's history.
Yeah, I love that about the case. It's almost like the facts of the case aren't as big of a deal as the kind of precedent that they established, which is that judicial review, that the Supreme Court has that power to strike down those laws. And it is funny that they agree with Marbury in the end, but because of that judicial review, they've given themselves that power. All right, anything else we need to take away because I know we have 15 cases, so we got to go fast. Any other beats on Marbury versus Madison before we move on to our next grouping?
No, Marbury judicial review next.
Got it. Okay, so we're going to look at kind of federalism and two cases, McCulloch v. Maryland and United States v. Lopez. So very shortly after Marbury, McCulloch v. Maryland, we're still in that founding era, 1819. So what do we know? What do we need to know about this case? What's important about it?
These two cases together go to the powers of the national government. And so federalism is that division of power between the national government and the states. And McCulloch v. Maryland and United States v. Lopez are sort of two, you could look at them as two different holes in the powers granted to Congress. And so McCulloch v. Maryland is 1819. It involves one of the great debates in the early American Republic, whether or not Congress has the power to establish a national bank. Under the Washington administration, Alexander Hamilton said yes. Thomas Jefferson and James Madison said no. And so this debate continues to reverberate in the decades to come. And McCulloch v. Maryland ended up being a conflict between the national government and the state of Maryland. McCulloch is an official from the Bank of the United States. What Maryland's trying to do is they have passed a law to basically try to tax the national bank out of existence. The state of Maryland doesn't like the national bank. It doesn't believe that the national bank is constitutional. And so they're trying to tax the national bank out of existence. McCulloch refuses to pay this tax. In this case, it ends up before the Supreme Court. And finally, for the first time in 1819, the Supreme Court has to weigh in on this big question of whether or not the national bank is constitutional, whether Congress has that power. Maryland's argument's pretty simple. It's the same one Jefferson and Madison made. And they say, Congress, where does it say in the Constitution you have the power to establish a national bank? There's no established bank clause. That's the end of story. It's not constitutional. The Bank of the United States is unconstitutional. John Marshall, though, steps into McCulloch v. Maryland, and he says, no, Maryland, you're interpreting the Constitution wrong. You're doing constitutional interpretation the wrong way. What we see with the Constitution is, yes, the Congress is granted a certain set of limited powers, enumerated powers under Article 1, Section 8 of the Constitution, but within that provision, too, is the necessary and proper clause, which speaks to the ability of Congress to sometimes find different means to carry out the ends that are listed in Article 1, Section 8. So this is where we get the idea of there being implied powers. So there are certain enumerated powers under Article 1, Section 8, like the power to regulate interstate commerce or to tax and spend for the general welfare. What Marshall's saying here is that if you take those powers and take the necessary and proper clause together, what we see is that establishing a national bank is a useful way to carry out some of the powers that are specifically listed in the Constitution. So a national bank's related to things like the government's power to borrow and spend and tax. And because of that, Congress has the power to establish a national bank. The national bank is constitutional. State of Maryland, you're wrong. But there's one other key point here in McCulloch, though, and it's that establishes the supremacy of national law. And so what Marshall also says here is famously, the power to tax is the power to destroy. Maryland, what you're trying to do is you're trying to use your taxing power to tax a national institution out of existence. That violates the supremacy of the national law. And as a result, that action too is unconstitutional.
So that was rooted in both the necessary and proper clause and the supremacy clause then, right?
Yes, those two parts are, exactly.
Those are the two parts of the Constitution you kind of have to remember when you're talking about McCulloch v. Maryland and that kind of federalism. And so speaking of federalism, we're going to look at the other case that, in this grouping, which is United States v. Lopez. So tell us about this case and why it's important to learn about it.
Absolutely. So United States versus Lopez, in a certain extent, we're in 1995 now, so closer to modern day. And it's a way where the Supreme Court is trying to step back in and say, no, restate the fundamentals that we are a government of limited powers. And so United States versus Lopez involves Alfonso Lopez. He brings a concealed weapon into his school. He's caught and he's charged under a national law known as the Gun-Free Schools Act of 1990. And that law banned individuals bringing firearms into schools. And Lopez argues that no, this law is unconstitutional. It exceeds the powers of Congress. Where does Congress have the power to regulate guns? And what the Supreme Court does is it steps in with a 5-4 decision and says, Mr. Lopez, you're right. We are a government of limited powers. It may be the case that since the New Deal from 1937 really onwards, we've read Congress's commerce power really, really broadly. But the Supreme Court says here with Lopez, we're going to make it clear that there are still limits to what Congress can do under the commerce power in the Constitution. And here what it says is, bringing guns into schools, that's a non-economic activity, and it's not substantially related to interstate commerce. As a result, a law like that is unconstitutional. So it's really about, once again, setting out limits on national power. As a practical matter, the Supreme Court hasn't built upon Lopez to write in a ton of new limits on the powers of Congress, but nevertheless, Lopez stands for the proposition there are still limits to Congress's power under the commerce power.
So that's really interesting to look at those two cases together and look at how with McCulloch, it was, the federal government was taking an act and the Supreme Court said yes, because they found those powers in the Constitution. But with Lopez, they couldn't find those powers in the Constitution. And so then it reverted to the states and that kind of state power. So that's when you're looking at the difference between federal and state governments and that kind of system of federalism.
Exactly. Lopez involves what the court would say is a traditional concern of the states, something like regulating guns and promoting the health, safety, and welfare of residents is within the core of the powers of the states usually.
All right, so great. So that's the federalism cases. Let's move on because this is a pretty meaty grouping right here, some pretty big ones. So looking at the Bill of Rights and balancing kind of those individual liberties with the government's job of creating order. So we have a whole list of them. So again, we have limited time, so we'll jump right in and start with Engel v. Vitale, 1962. What's this case about, Tom, and why is it important?
Yeah, so this is one of the important school prayer cases. So it's a 6-1 decision written by Justice Hugo Black, and it involved the New York State Board of Regents prayer that it authorized to be recited in public schools at the beginning of the school day. Here's the prayer: Almighty God, we acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teachers, and our country. So it's a non-denominational prayer. And you're basically inviting the students to prayer voluntarily at the beginning of the school day. Some parents step in and say, no, that violates the First Amendment's Establishment Clause. And ultimately, the Supreme Court agrees with the parents. And what it says, and I think what the important thing that's animating it for the courts here is, I think the courts are concerned about young kids being in schools subject to the coercion of the state and teachers and people in authority. And so as a result, being coerced into or expressing certain views that they don't have when it comes to religion. And so there's a massive backlash against this case, but ultimately the Supreme Court holds its ground and extends this ruling into contexts like high school graduation ceremonies. That's the case Lee versus Wiseman, and football games, which is Santa Fe Independent School District versus Doe. At the same time, the court does say that prayer can exist in certain other governmental settings, usually involving adults, like the beginning of Congress, there could be a prayer, or the beginning of town councils.
Okay, so and again, this was we're looking at, if we're looking at the constitutional provision, it's the First Amendment Establishment Clause for this one, and saying that having students say prayer in school violates that Establishment Clause. So, and then moving on to kind of keeping on that religion umbrella of the First Amendment, we have Wisconsin v. Yoder. So tell us about this one.
Yeah, so now we're in 1972. It's a 7-0 decision authored by Chief Justice Berger, and it pits the state of Wisconsin against some Amish families. And so there's a law in Wisconsin, like many other states, that require families to send their kids to school up to a certain age. And what the Amish families come in and say is that, no, your requirement of us to send our kids to school past the 8th grade violates our religious views. And so this requirement to send our kids to schools all the way up through high school violates the First Amendment's free exercise clause. So this is one of those classic examples of a religious challenger coming in and saying a law the government's passed that applies to everyone violates one of our violates core religious views here involving sending our kids to school. And the Supreme Court ultimately sides with the Amish families. And it says, that you here have expressed something where you have a legitimate reason, a legitimate religious objection, and in the end, the state doesn't have a really good reason to have your kids go to school. And as a result, the Amish families win here. And that's highly unusual. There aren't, up until that point at the Supreme Court, many religious challengers that win. But this is a very strong statement of religious liberty rights under the First Amendment's free exercise clause.
Okay, that's great. And I think that's a really great very clear definitions of the free exercise clause with Yoder versus the Establishment Clause with Engel and Vitale, like kind of looking at those two religion aspects of the Constitution and seeing how they are different, and the way the Supreme Court interprets them. So another really important thing to keep in mind, students. Something else, Tom, you said it was a 7-0 decision, and I think just a really quick non sequitur that points out that, the Supreme Court, we kind of think of them as 9 today, but there haven't always been 9 justices on the Supreme Court. So like I said, an important thing to remember about the Supreme Court.
Yes, it's either sometimes there's vacancy, sometimes actually there are times with the court where there's a lot of old justices and they can't actually decide every case. And so it just varies.
All right, so staying with the First Amendment, we're going to look at Tinker v. Des Moines. I love this one because I know Mary Beth Tinker. She's really great. But tell us about Tinker v. Des Moines and why this one's important to remember.
Yeah, so that's a Mary Beth Tinker on the left there. And so this is an important First Amendment free speech case in the context of schools. And so these are 2 students who go to school wearing those armbands you see them holding up there in protest for the Vietnam War. And so the students are disciplined by the school for wearing these armbands, but they go to court and they say, no, you're violating our First Amendment rights. And the Supreme Court in a 7-2 decision says, Tinkers, you're right. The school is wrong. in this context. The famous quote here is that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. And so here the court says that these armbands were just a constitutionally protected form of symbolic protest. At the same time, this court is clear that there are certain different free speech rules that apply in schools versus what applies to society writ large. And so schools and teachers and school officials have more flexibility to regulate speech than the government does in other contexts. And the key standard here is that speech acts must not materially or substantially interfere with the school's operations. The idea being that we create schools to educate kids, and that if we have speech acts that are violating materially or substantially interfering with that, the school has a real interest in regulating that. But that wasn't the case here. There was no disruption, and so the Tinkers win.
Yeah, I love that this is still kind of an issue today. We just heard last year there was a big free speech in schools case with Mahanoy right out of here in Pennsylvania. So I love that these cases can relate to our students who are watching today. This pertains to you guys. So it's these cases aren't just these big overarching issues. They really affect all of us in our day-to-day lives. So that's something I like to remember too.
Absolutely.
All right, so moving on, we've got some more Bill of Rights cases. This one is New York Times and Company versus United States, 1971.
Yeah, so 1971, this is also known as the Pentagon Papers case. And so this case covers one of the core rights to freedom of the press. And so in particular, it's what's known as the rule against prior restraints. And so if we're thinking about the First Amendment, one of the key things that we say government, generally speaking, can't do is it can't keep, say, a newspaper from printing a story. And so there's a strong, what's called a heavy presumption against prior restraints. And the idea being that we want the default rule to be that we can print what needs to be printed. If in the end it violates the law in a certain way, that the publisher can be punished, but that we don't want the government stepping in and keeping things from being published unless there's a really, 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 really good reason for that. And so here in the Pentagon Papers case, this involves the New York Times and eventually the Washington Post printing what were known as the Pentagon Papers, which was a classified Defense Department study that examined the history of US involvement in the Vietnam War. It was Daniel Ellsberg, who worked at the Rand Corporation, knew of these Pentagon Papers, and he literally took photographs of 4,000 pages of these papers, sent them along to reporters. The Nixon administration saw this and ultimately stepped into the court and said, no, you have to keep the newspapers from printing this information. It could compromise our national security. Stop the presses. And the Supreme Court ultimately in a 6-3 per curiam decision says, no, Nixon administration, you lose. Here, we have to remember again, there's a heavy presumption against prior restraint. You're asking for a prior restraint here. You're asking us, the court, to step in and say that these newspapers can't publish this information. This is core political speech about government policy. It's at the core of a First Amendment value of making sure that we can check abuses by the national government and making sure that the populace is informed of what's going on. So no, Nixon administration, you lose.
Man, this First Amendment was getting a lot of play in these cases. So we've got freedom of the press, freedom of speech, both religion clauses. It's really makes you remember how important that amendment is.
Absolutely.
All right. So one more in this category before we move on to the next one, and that's Schenck v. U.S. 1919.
Yeah. So this is in the context of World War I. The defendants here are charged with mailing printed circulars designed to obstruct the military draft during World War I. They're charged on what's known as the Espionage Act of 1917, which made it illegal to spread information that undermined the war effort. The reason we still study this case is it's a 9-0 decision authored by Justice Oliver Wendell Holmes. And this is where Oliver Wendell Holmes establishes what's known as the clear and present danger test. And so ultimately the Supreme Court upholds the conviction of these defendants. It says the First Amendment was not violated by prosecuting them under the Espionage Act. And so this case becomes a reminder that First Amendment protections aren't absolute, that in the context where the court concludes in this case that there's a clear and present danger, that Congress has the power to regulate or to prescribe or to ban, that ultimately we can uphold those laws and uphold those convictions. The famous quote here is that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. What we'd see, though, is the Supreme Court would eventually turn against or turn away from this approach to the First Amendment, read First Amendment protections much more broadly, as we've already seen from some of the cases that we've learned about today, following a series of dissents by Justice Oliver Wendell Holmes and Justice Brandeis in the 1910s and 20s.
Yeah, and our free speech protections, Jeff always points this out, is we have some of the most free speech protections in the world here, like in the United States. So.
Yeah. And so Schenck is it's a funny one to study because it's sort of like the counter to that. It's teaching the lesson that free speech protections aren't absolute, but in the end, we end up having, again, today we probably have stronger free speech protections than at any other time in our history. And as Jenna just said, the United States has the strongest free speech protections probably in the entire world.
But like you said, not absolute, but pretty strong. Okay, so the next, we're still sticking with the Bill of Rights, but kind of talking about incorporating those Bill of Rights into the states, because we know that didn't happen right away. The 14th Amendment, we've talked about incorporation a lot in the classes, so we won't dive too deep into that. But maybe a quick beat on incorporation, and then we'll get into the cases, starting with Gideon versus Wainwright.
Sure. So, I mean, incorporation is the idea that when the Bill of Rights was originally ratified in the founding generation, it applied only to abuses by the national government. It didn't apply to state laws, actions, practices. But with the ratification of the 14th Amendment in 1868 and later Supreme Court decisions like Gideon versus Wainwright, we've decided to apply core protections of the Bill of Rights against the states. We call this incorporation. The process is what's known as selective incorporation, which means the court will look right by right, case by case, to decide whether to apply a particular Bill of Rights protection like free speech, free press, et cetera, against state abuses. In Gideon versus Wainwright, the question becomes whether or not the Sixth Amendment's right to counsel should be incorporated against the states. Right here, we see Clarence Earl Gideon, who was the defendant in this case. He's charged and convicted of a burglary in a pool hall in Florida. He's poor. He tells the court, I can't afford a lawyer. And Florida says, that's too bad. You're out of luck. We don't give lawyers to people in your situation where it's basically a petty crime. And so Gideon has to represent himself. He loses, but then he goes to the Supreme. He ends up in prison. He studies the Constitution. He writes his own petition to the Supreme Court, and the Supreme Court takes his case. So they have this handwritten petition from Gideon. They say, yes, this is a great issue. It's a great case. They take Gideon's case, and in a unanimous 9-0 decision by Justice Hugo Black, the Supreme Court decides, one, yes, we will incorporate the Sixth Amendment's right to counsel against the states. And two, because of that, Clarence Earl Gideon, you win. Your conviction is thrown out. You will have a new trial. Ultimately, Gideon then receives a lawyer in that new trial, and he's acquitted.
Yeah, it's great that Gideon got his new trial and won his case. But like you said, the bigger implication of this case is incorporating that Sixth Amendment right into applying to the states as well as the national government.
Exactly.
All right. Moving on, we're going to look at Roe v. Wade, 1973.
So yeah, Roe v. Wade, it has less to do with incorporation, but more to do with whether or not there are certain rights that people have that aren't specifically listed in the Constitution. These are known as unenumerated rights, things like the right to privacy. And so when Roe v. Wade involved a Texas woman, Jane Roe, who sought an abortion, but there was a Texas law that banned abortions, except in contexts where a woman's life was in danger. And so here, the Supreme Court hears this case. Roe argues that this law is unconstitutional. And in the 7-2 decision authored by Justice Harry Blackmun, the Supreme Court agrees with Jane Roe and strikes down the Texas law. Ultimately, what the court says is, that it ends up applying the right to privacy that it found in Griswold versus Connecticut in 1965 to this context to include a right to an abortion. And so here, what the court is effectively saying is that there, again, much like in Griswold and Roe v. Wade, it's saying there are certain rights that people have that aren't specifically listed in the Constitution, but nonetheless can be protected against state abuses. Here, it's a right to an abortion.
Okay. And finally, in this category, we're going to look at McDonald v. Chicago, 2010. So this is a Second Amendment case.
Yeah, so this is a case involving whether or not the Supreme Court should incorporate the Second Amendment's protection to keep and bear arms against the states. McDonald followed a previous case, District of Columbia v. Heller in 2008. That case involved a handgun ban in Washington, D.C. The Supreme Court in a 5-4 decision struck down the D.C. handgun ban and basically said that the Second Amendment includes an individual right to keep and bear arms for purposes of protecting your own home. But because Washington, D.C. was a federal territory and not a state, it's still left open to the question of whether or not the Second Amendment should be incorporated against the states. That issue came up here in McDonald versus City of Chicago 2 years later, and the Supreme Court in a 5-4 decision said yes. In the end, the right to keep and bear arms for purposes of protecting one's home is deeply rooted in American history and tradition. Therefore, we are incorporating the Second Amendment against the states. Now, here the Supreme Court was clear, like every other right, the Second Amendment right is not absolute. The Supreme Court in Heller specifically said, long-standing regulations like keeping guns from schools, keeping guns out of the hands of felons, we're not upsetting those particular laws with these decisions. But in the end, it's recognizing a core protection, a core individual right to keep and bear arms for the protection of one's home.
And so again, that selective incorporation means that they're not all covered, but sort of case by case, the Supreme Court has incorporated those 10 amendments kind of one by one and applied them to the states. And it's not all of them, I think, where there's still a couple of those liberties that hadn't been applied, but in the grand scheme of things, they've, through the process of selective incorporation with these Supreme Court decisions, have applied Bill of Rights protections to the states.
Yeah, the big idea is that we've incorporated virtually every right against the states by this point in time.
Okay, so the next category with a case all on its own is equality. So the 14th Amendment's protection clause, this is from the AP course, the 14th Amendment's equal protection clause, as well as other constitutional provisions, have been used to support the advancement of equality. One of the biggest cases, to look to for this is Brown v. Board of Education in 1954.
Yes, this is maybe the most famous Supreme Court decision of all time. It's a unanimous decision by the Warren Court. It's a challenge to school segregation laws. So these are laws that made different schools for white children and African-American children. Brown involved a series of challenges from a variety of states and settings throughout the United States. It built upon a long-term litigation strategy by the NAACP Legal Defense Fund, lawyers like Thurgood Marshall. In the end, what they're doing is they're challenging the Supreme Court's own ruling in Plessy v. Ferguson from 1896, which said that effectively Jim Crow laws that create separate facilities that are equal, that those are constitutional. And so here, what the students and their families are saying is, no, Plessy v. Ferguson is wrong, and school segregation violates the 14th Amendment's equal protection clause. And the Supreme Court, again, in an opinion by Chief Justice Earl Warren, unanimous opinion, said, you're right. School segregation is unconstitutional. It violates the 14th Amendment's equal protection clause. Here's the key quote. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
Yeah, it's such an important decision. But I think it's important to also point out that, that didn't end segregation immediately. It took actions of the different state governments and even in some cases, the federal government stepping in, we know in Little Rock, and kind of enforcing the Supreme Court's decision here with Brown v. Board.
Yeah, and Congress with the Civil Rights Act of 1964 played a key role in reinforcing Brown.
Okay. All right, now we're looking at campaigning and electoral rules, and this is a key case from 2010. I think it's our most recent case on the list, and that's Citizens United versus the Federal Election Commission, or just Citizens United is often called.
Yeah, so this is another case involving the First Amendment. It involves a law known as the Bipartisan Campaign Reform Act, and it involves a film called Hillary the Movie, which is put out by an organization called Citizens United, and Citizens United in the title. And the law itself that's challenged here under the First Amendment effectively banned political spending by corporations and labor unions. And so the idea being some of the money that was used to fund this film that was attacking Hillary Clinton during the presidential campaign of 2008 came from the general treasury funds of corporations. And so here Citizens United is challenging that congressional ban on political spending for corporations and labor unions. And the Supreme Court in a 5-4 decision said, Citizens United, you're right. And effectively it struck down this congressional ban on political spending by corporations and labor unions. And again, it shows just the very broad protections that the Supreme Court has recognized under the First Amendment over time.
What were the reasons behind siding with Citizens United?
It was, the idea is that, in the end, we're talking about poor political speech. And there may be some criticism of corporations from certain quarters and their participation in the political process, but that alone wasn't enough to justify basically what the Supreme Court would say would be not allowing the speech they want to fund to be part of public discourse. So it's really just, in a sense, a broad reading of those core protections for allowing all sorts of ideas to sort of flourish out there in the world and allowing for a pretty open and robust marketplace of ideas.
Okay, thanks, Tom. That's helpful. All right, one more category to go. I know we're almost short on time, but we'll get through them. So this is kind of the structure of the legislative branch, and we're going to look at Baker v. Carr and Shaw v. Reno. So we'll start with Baker v. Carr. So tell us about this case and why it's important to learn about it.
For Baker v. Carr, we're back in 1962. It's the Warren Court. This is a 6-2 decision authored by Justice Brennan. And this case is dealing with the way in which we draw districts for elections. And so this is a challenge that took place in Tennessee. The Tennessee legislature hadn't redrawn its legislative districts in over 6 decades. And so the argument here is that what we're seeing is legislative districts aren't tracking population growth. And so over this period of time, we're seeing a growth in population in urban areas, relatively less population in rural areas. And this is a challenge saying that what you're doing is you're making some votes count more than others. And that violates the 14th Amendment's Equal Protection Clause. The Supreme Court, a little over a decade prior then, had said, no, we're not going to hear decisions like this. These are questions that, we really want to leave to the political process. Baker v. Carr is important because it's the Supreme Court stepping in and saying, no, this claim is a legitimate claim. It's a justiciable claim that we, the Supreme Court, can hear. And so as a result, we, the Supreme Court, are going to consider these reapportionment challenges. And eventually, 2 years later, in a case known as Reynolds v. Sims, the Supreme Court would establish the idea of one person, one vote. And so this is the idea that we want legislative districts to be really pretty close in population one to the other, because we want everyone's vote to count the same. What's pretty amazing about this is that Chief Justice Earl Warren, near the end of his time as Chief Justice, would call these cases, Baker v. Carr and Reynolds v. Sims, known as the reapportionment cases, probably the most important cases that he decided. And so again, he authored Brown versus Board of Education. He really thought these cases were a big deal too.
Yeah, I know the College Board kind of lumps these as structural to the legislative branch, but they really are about equality too, that equality in representation. So I think that's important to think about, that one person, one vote, and so speaking of which, let's look at the other case about the districting, which is Shaw v. Reno.
Yeah, so Shaw v. Reno has to do with the issue of racial gerrymandering. And so these are cases that bring up the question of whether or not, when drawing legislative districts, a state has relied on race too much in deciding how to draw districts. And so this involved a district in North Carolina, a couple districts that were designed to allow for majority African-American districts. But you could see the main district that was at issue is that pink one that you see. It was meant to cut down basically an interstate in the middle of the state. And what happened is that people then came in, residents challenged this oddly shaped district under the 14th Amendment, saying that, the legislature, when creating this district, took race too much into account, and therefore this districting map is unconstitutional. And the Supreme Court, in a 5-4 decision by Justice Sandra Day O'Connor, said the challengers are right. And effectively what the Supreme Court is saying here is that, we don't want race to be the overwhelming factor when choosing how to design districts. And so one of the things that Shaw v. Reno establishes is that if you have a district like this, which is really kind of in a regular shape, in the end, the state can design districts like that. But if they're going to do it, they have to have a really good reason for why they designed the district this way versus through some other means or some other reason.
Got it. Okay. All right, well, that was all 15 cases in 34 minutes. I think we did a pretty good job. Any final thoughts, Tom? And then we do have a couple questions, so I'll ask you to hang back just to answer a couple questions. But any final thoughts before I officially end class?
No, just good luck. If anyone on here is taking the AP exam soon, good luck.
Yeah, good luck. And if you are thinking about taking an AP course, I hope that we gave you a little test of what's to come. All right, so oops, I think I left. So 1 second, let me just.